Good morning, Mr. Schiff.
Good morning, and may it please the Court. My name is Ryan Schiff, and along with Beth Eisenberg and Lorenzo Perez, I represent Mr. Coffin. On March 1st, 2006, when the Commonwealth filed its sexually dangerous person petition, the only basis for Mr. Coffin's imprisonment was a sentence imposed by the Massachusetts Parole Board for a violation of his lifetime community parole. But just 1 week before the Commonwealth filed that petition, it had filed in the Fitchburg District Court a memorandum conceding.
I have one question for you, and it may be the difference between a constitutional issue and one that is not. If we were to decide in your favor, then what happens to all the offenses in which the defendant must be a prisoner in order to commit the offense? Would those sentences have to be vacated if the statute under which they were originally sentenced is later declared invalid?
I don't think necessarily, Your Honor, and the reason why is because in Commonwealth against Gillis, this court held that interpreting what prisoner means for the purposes of the SDP statute, it has to apply a very narrow version of that.
Well, I'm not talking about in terms of the SDP statute. I mean, just for instance, if a prisoner assaults a correction officer,
yes, Your Honor,
then he's sentenced to such and such. So what would happen if later the statute is later declared invalid?
Well, I think this court could make clear in a decision that the version or the definition of prisoner that it's using for this SDP statute is specific to that statute, and this was something that the court recognized in Gillis, where the court rejected.
But you're not answering my question. Forget SDP. Just
yes, Your Honor.
Say there's some defendant who's convicted of assault and battery on a correction officer, and one of the elements is you must be a prisoner. Just say that one of the elements is. I'm not sure that it is, but and then we decide that statute is invalid. Does his sentence have to be vacated because he wasn't a prisoner at the time that he assaulted the correction officer? Well, there were lots of statutes like that.
Yes, for the specific reason that Mr. Coffin's lifetime community parole was invalid, I don't know of any case law that answers that question. What we are talking about here, though, in our argument about why he was serving a sentence that was at that time void, this is a very narrow set of circumstances. We're not talking about something where a procedural error takes place at a... That is,
I think, Justice Cowen's question. Is
yes.
it because Pagan, if I'm saying that correctly, declared the statute void, unconstitutionally void? I mean, is it the fact that it's a constitutional error?
Yeah, and more than just a constitutional error, because this is a constitutional error that goes to the authority of the court to even impose the sentence. There was no constitutionally valid authority permitting the court to impose lifetime community parole on Mr. Coffin.
So is it your view that upon the rescript of the Pagan decision, Mr. Coffin could simply have walked out of jail and said, it's void ab initio, I'm not a prisoner, and I'm going to just leave?
Absolutely not. The argument made by the Attorney General in their amicus brief is not responding to that argument, is really responding to an argument that we've never made.
Okay, so if he's not allowed to leave, then that means he's lawfully a prisoner until a court vacates the sentence.
I don't think that's necessarily correct, and the reason why is because we certainly agree with the Attorney General that it promotes the rule of law to tell defendants, tell prisoners, if you have a constitutional error with your sentence that means that you're being held illegally, you should go to the courts to get redress. That's a perfectly sound rule, and it does promote the rule of law. What we're talking about is how, looking backwards, we're to view the legal significance of his imprisonment for the purposes of evaluating whether there was jurisdiction for the sexually dangerous person petition.
I take it that it might be complicated, but I take it that in Justice Cowen's hypothetical, which I understand it's not your case, we don't force counsel to answer things that aren't their case, but I take it that if it turned out that an element of the particular crime for which the defendant had been indicted was that you had to be incarcerated You couldn't, for example, assault a correctional officer on the street while you're on parole. An element was you were in the prison, and there's, let's say, a heightened sentence or something because you're in the prison and you're assaulted. And then it turns out you shouldn't have been in the prison in the first place. I take it that the defendant would have brought a motion, and I agree with you, I think the Attorney General is reaching for something that's not at issue here, would have had the court declare that constitutionally the Commonwealth had no right to hold him, and it is possible that as a consequence of that, that crime might have to be, that conviction might have to be vacated, which may or may not prevent the Commonwealth from indicting on a straight assault and battery where an element isn't. I don't know about that. But I take it that it's not, that this is a very different, very narrow, very separate statute, but its essence goes to the same thing. How much do we have to undo? How much do we have to undo when we find out that a defendant, having properly come to court and had his particular sentence declared constitutionally invalid, how much do we have to undo of what the Commonwealth did to him during the period of time when he should not have been incarcerated, correct?
That's exactly the issue. And in answering that issue, I think...
And to suggest, frankly, that this defendant is claiming that he had a right to walk out without going to court, I found bizarre.
I agree with you, Your Honor, and we have never made that argument, nor is it consistent with what Mr. Coffin did. I think it's important to keep track both of the nature of the constitutional error that took place here. This was an error that went to the very constitutional authority, or the constitutionally valid authority of the court to even impose the lifetime community parole. And then second is the specific procedural history of this case. Mr. Coffin didn't sit on his rights.
Right. But could I just ask you
Yes.
this? I mean, this is it is a different case, though, than either Gillis or the appeals court, Allen, right?
Well, it's much more similar to Allen, but there are some differences, yes, Your Honor.
Well, except that physically, well, yes, it is more similar.
And the reason why it's similar to Allen is what Allen rejected was the notion that it is enough that the fact of incarceration can justify jurisdiction for a sexually dangerous person petition. And that clearly is not the case. And that wasn't the case here because he wasn't being held lawfully. And he was far along in challenging the lawfulness of his detention at the time the petition was filed.
If I remember this correctly, and I may not, but wasn't it the case that in Allen, at the time that the petition was filed, the court had already said he's out of here?
Well, what had happened in Allen was that he wasn't properly given credit to his sentence.
I mean, the court actually said that before the SDP petition was filed?
Yes, Your Honor. The day before the SDP petition was filed, the court had said that he should be awarded those credits. He hadn't yet been awarded those credits. And the appeals court said that there was no jurisdiction for the SDP petition.
Okay, but I mean that is a difference, right? Because you have a switch of a day.
Well, it is a difference, but it's a very technical difference because here the Commonwealth had already conceded that he had been sentenced to lifetime community parole without any constitutional authority.
Before they commenced the SDP petition?
1 week before, on February 24th of 2006.
So it's the same thing.
Yeah.
I mean, we don't have a particular adjudication because he hasn't gone in to say, I'm one of those people.
No, you
But the Commonwealth had knowledge that they should not be, that in all probability, upon the filing of a habeas or whatever other petition he was going to file, there would be a determination that he shouldn't be there, and they just moved quickly.
That's correct. In essence, the Commonwealth's position here is that so long as they managed to get their SDP petition through the Superior Court doors before the District Court had an opportunity to act on their concession, that there was jurisdiction.
Let me ask you about resisting arrest. If there were an unlawful arrest, it shouldn't have been made and it shouldn't have happened. Say it was under a disorderly statute and we declared that part of the disorderly statute unconstitutional.
Yes,
but the person, while he was being arrested for disorderly conduct, which later is declared invalid, if he resists arrest, then don't we still prosecute him for not surrendering, regardless of whether the arrest was valid?
Yes, and for very good reason, and those same reasons are not present in this case. And the
You
reason
can't do self-help.
I'm sorry, Your Honor?
You can't do self-help.
That's
We've said that
absolutely right.
in 100 cases. You
That-
cannot do self-help.
That's right. That would be more akin to Mr. Coffin having walked out the jail doors
In other
instead
words, if
of...
somebody comes, I mean, I don't want to get into land cases, but there was a recent land case when you said you can't do self-help.
That's right, Your Honor, and that certainly isn't what Mr. Coffin did here. He within the record shows that I think it was September 14th of 2005 is when this court decided Pagan. I'm sorry.
Go ahead, finish.
October 1st is when he had been serving a 90-day sentence for breaking and entering into a car. October 1st, he starts serving his sentence for violating lifetime community parole. And by the middle of October, he's going to CPCS asking that counsel be appointed. And then counsel gets appointed. The record isn't clear about when that occurred. And in December, counsel files the motion. In January, counsel files a motion asking for a hearing. That hearing then didn't take place until March 8th. And during that time, the Commonwealth waited then until March 1st to file its response, and its response was a concession that he was being held without any constitutional authority.
Is that determinative here? In other words, if in fact he hadn't done anything until the petition was filed and then said, oh, no, I was wrongfully incarcerated under an invalid statute, I've just learned this. Is it determinative, or is this something we should distinguish this case from other cases on?
Well, our position is that any time somebody is being held for a sentence that was imposed with no constitutionally valid authority, that imprisonment can't be taken to form the basis of a jurisdiction for an SDP petition. But I think the court could write a decision that was based very much on the specific facts of this case.
When you say no constitutionally valid authority, do you mean that no court under any circumstances, under any properly written statute, could have authorized his detention? Or do you mean that the statute under which a court having constitutional authority to incarcerate somebody was incarcerating somebody under a statute that was unconstitutional?
Incarcerating somebody under a statute that was unconstitutional. And, in Pagan, as you well know, the court held that when somebody is charged as a first-time offender, is not charged as a repeat offender, that the only statutory provision that permitted that person to be sentenced to lifetime community parole was void for vagueness, was unconstitutional because it did not provide the notice that is required, or it wasn't clear enough to meet the standards of due process. So there was no statute that was in place that was constitutionally valid that permitted the court to sentence Mr. Coffin, who had been charged only as a first-time offender. There was no allegation in the complaint prior to sentencing or even at sentencing that he was a repeat offender. There was no authority there for the court to impose this sentence, and therefore that sentence should be deemed void ab initio from the beginning.
So am I correct that if there were a different situation, that if he was convicted, say, of a non-sexual crime after having previously been convicted of a sexual offense, and that he later appealed that and prevailed on appeal, he would not be able to say, well, that conviction was vacated on appeal, I should not have been a prisoner, and therefore I should not be an SDP?
That's right, Your Honor, except under those unusual circumstances where the statute under which the person was convicted was itself facially unconstitutional, like, say, the Texas sodomy statute that was held unconstitutional by the Supreme Court. If somebody had been convicted under a similar statute, that statute is deemed itself facially unconstitutional. Somebody can't, under any circumstances, be prosecuted under that. I don't think that could form the basis of an SDP petition. But the sorts of normal reasons that people's convictions get reversed, errors that take place at trial, those are voidable at the discretion of the court, as the Commonwealth has described what can be done under those circumstances. They claim that that's the case here, that this was voidable at the discretion of the judge, and it clearly was not. The judge had no discretion. The judge didn't have to make a factual finding. You didn't have to weigh prejudice, didn't have to do any of those things. All the judge had to do was look at the charging document, see that he was not charged as a repeat offender, and then know right away that he could only have been sentenced under to lifetime community parole under an unconstitutional statute. So there was no discretionary work for the court to do. This was a sentence that was void from the very beginning and cannot and should not form the basis for jurisdiction for this SDP petition.
And just tell me again, in terms of the sequence of events, was the statute determined to be facially unconstitutional before or after this defendant had his SDP hearing?
It was before. It was September of 2005. The Pagan decision came down.
So he was committed.
He hasn't yet been committed.
Okay.
As an SDPer.
That's right.
Yeah.
That's right. He's being held under Section 12 after finding a probable cause.
Yeah.
Thank you, Mr. Schiff.
Thank you very much.
Good morning, Ms. Lazar-Moore.
Good morning. Ellen Lazar-Moore for the Commonwealth. The Commonwealth properly filed its SDP petition in this case when the petitioner was held on valid legal process serving a term of penal confinement. That his lifetime parole sentence was later stricken does not require dismissal of the SDP case because his sentence was still in effect when the SDP petition was filed. He was not a party to Pagan, and his sentence did not simply become void when the Pagan decision
Ms.
was
Lazar-Moore,
issued.
isn't that form over substance? Because if we agree with the Attorney General that, of course, somebody can't just walk out, that Mr. Coffin cannot walk out the day after Mr. Pagan's decision comes down. He has to go into court and get permission, and he's never claimed otherwise, correct? Do you agree?
No,
He's never claimed otherwise.
No, he has not.
So the Attorney General has filed a brief on something that isn't an issue in this case, correct?
Well, I don't believe that the Attorney General or anyone ever claimed that Mr. Coffin was arguing that he could have simply walked out.
So that's not an issue here. So he has to go to court. We know that hearings take a while, but nobody doubts what the outcome of that will be, and the Commonwealth, in fact, concedes that that's what the outcome will be, because there's no other basis to keep him incarcerated.
Well, I disagree. Go on, Your Honor.
And you are saying that the Commonwealth can then go in the day that he files his petition seeking release and obtain jurisdiction under the SDP statute. Am I correct?
Yes, Your Honor, because his criminal sentence was still in effect until a judge pronounced otherwise. And I disagree with the statement that, well, we all knew what would happen, therefore suddenly this sentence was void, as though it didn't exist. Every day of the week, parties make agreements that judges reject. Plea agreements, settlements of cases.
I think Mr. Coffin, Mr. Schiff, on his behalf, has argued very specifically. He's not talking about any case where, under a perfectly valid statute, a particular defendant may or may not, should or should not be incarcerated. He's making a very narrow claim, which is only when there is no conceivable basis, no constitutional basis that any individual can be incarcerated for violating that particular statute, because that statute is facially unconstitutional. So forget Mr. Pagan, forget Mr. Coffin, take Mr. Joe Citizen. After Pagan comes down, the Commonwealth cannot proceed, or judge cannot sentence lifetime parole. So he's not talking about all those other little private agreements, plea bargains, convictions that are reversed on appeal. He's only talking about where the basis, the statutory basis for incarceration is unconstitutional with respect to everybody.
But, Your Honor, I don't see how the line can be drawn as Mr. Coffin says. In response to Justice Cowan's earlier question, I do think that if the court were to hold, as Mr. Coffin argues, that all those statutes where someone has to be a quote-unquote prisoner in order to be convicted or get an enhanced sentence or lose good time, that all of those come into question when the underlying sentence that made the person a prisoner is vacated or overturned.
Why? Because the court clearly, in all of those cases, had jurisdiction, and nobody's suggesting that it didn't. Here the claim is the court didn't have, constitutionally it didn't have jurisdiction to impose that sentence. There was nothing wrong in your cases, all of those cases, with the judge imposing those sentences. There may have been an erroneous jury instruction. There may have been, any other normal appellate reason to overturn a sentence.
Well, one, nobody knew, of course, at the time that the sentence was pronounced,
No, but
that
we knew,
that statute would later be stricken.
No, of course not. Nobody's second-guessing the Commonwealth,
But to issue a decision, to create a rule whereby at any time, 30 years down the road, somebody's sentence, somebody's custody could retroactively be deemed void. And the argument here was that my custody was always void. My custody was always unlawful. Even though you didn't know it, even though Pagan wasn't issued until years later, it never was legal. I don't see where you can draw a line and say, well, some things have to be undone, but other things do not have to be undone. I mean, I don't know how, I can't think of any way that statutes are ever struck down other than upon a finding that they're unconstitutional.
Well, it's an interesting question, and the next case that we're going to be hearing today has a variation on this theme. And the restatement of judgment suggests that a subsequent judgment that depends upon the validity of an earlier judgment may be valid even if the earlier judgment is vacated, but it depends upon the circumstances under which the earlier judgment was entered. And in this case, it seems to me the defendant is saying, this is the extreme case. The earlier judgment is one that rested upon the total invalidity of a statute that authorized activity upon which a later judgment was going to depend.
Well, it actually, I should say, was not the total invalidity of the statute. As applied to this particular defendant, Mr. Coffin, in his criminal case, it was that the indictment did not charge him as a second offender when it could have, because he had prior sex offenses. Therefore, he was not put on notice, as required by Pagan, that he could be subject to lifetime parole. So it was not the total invalidity of the statute. But even if it were, at the time the sentence was imposed, that statute was in place, that statute was valid, and that sentence was valid until the time that Judge Mandel changed it. And that the Commonwealth wrote a memorandum saying, yes, we agree that in this case lifetime parole was wrongly imposed because the indictment didn't charge him as a second offender, had no legal effect until a judge looks at that, looks at the defendant's claim, and says, yes, I agree, I'm going to resentence you. As a perfect example, in what happened here, the sentence that Judge Mandel ended up imposing that day changed several times over the course of the day. As the parties made their arguments, made different agreements, changed the agreements, it was not clear until Judge Mandel finally imposed sentence and the people walked out of court what that new sentence was going to be.
That's correct, but there's no question that one of the options he couldn't continue to forget about the Commonwealth's concession. One of the options he couldn't exercise was to say, well, they've said it's wrong and Pagan, but I'm doing it here.
Well, of course he could have. And then if the defendant wanted to appeal, I'm not saying that that would have been a correct decision, but he could have done that, and if the defendant disagreed, he could have appealed, but the sentence would still have been in effect. If the defendant disagreed with his decision, he couldn't have just said, you can't do that, you're wrong, my sentence is void, and left. And again, no one's claiming that he tried to do that, but my point is the judges make wrong decisions all the time that are overturned on appeal, but nobody says that that judge's decision was meaningless because it ended up being wrong, even though an appellate court didn't announce that for years.
But his point isn't that. I mean, it seems to me his point is, yes, if all those things had happened, Mr. Coffin would have to stay in the jail, no question about it. But if you're looking at the validity of an SDP adjudication, you can look back and you can see at the time that he was, when probable cause was found, was he validly in custody? Was he validly a prisoner? And your answer may be, even though he couldn't walk out the door, your answer as a legal matter is, no, he wasn't, because of the constitutional fault in the statute.
I would disagree with that, Your Honor. And I cite cases in my brief, DuPont, Lynch, Lewis, where the court has said a duly imposed sentence remains in effect until it is reversed by a court with jurisdiction.
And which of those cases had declared the statute facially unconstitutional?
None. But again, I don't see where the line can be drawn
I know
in that way.
you don't see the line, but I'm asking you to see the line. You can give me a reason why we shouldn't draw the line there, but there is a difference. If the answer is none, I'm going to ask you why.
Okay, in none of those cases was the underlying statute declared unconstitutional. However, I don't see the difference between, let's say that while Mr. Pagan was in on one of his lifetime parole violations, he assaulted a correctional officer. He would now say, because I never should have been in, because under Pagan, I shouldn't have gotten lifetime parole, my sentence was void, I never was lawfully held, I never was a quote-unquote prisoner, and because I wasn't a prisoner and you need to be a prisoner to be convicted of assaulting a correctional officer, I can't be convicted of that. In the Commonwealth's opinion, that is the wrong result, and that changes the current law under the cases cited in the Commonwealth's brief. Under the law as it stands now, it is a bright line, clear rule that has to date not covered facially unconstitutional statutes. You may be right. Perhaps it hasn't, Your Honor, but I think that it's not only the correct rule.
Have you looked at other states?
I have not found.
So you can't tell us where we have a facially unconstitutional statute that's applicable to everybody, where there is no consequence if an element of the whatever the proceeding is, criminal as an assault on a correctional officer or quasi-civil as an SDP proceeding, where there's no, it doesn't make any difference.
I'm not sure I understand your question.
Well, that in fact, to go to Justice Spina's point, that they're all the same, that the restatement is wrong, that they're all the same. It doesn't depend on anything. It doesn't depend on anything. If you were in there because some judge put you in there, which is really your argument, if in there meaning incarcerated, if you were in prison because some judge put you in there, it doesn't matter why, whether the judge was wrong for this reason or that reason, they're all the same.
Unless the court didn't have jurisdiction to issue the sentence, because that's the line that the cases have drawn, that a sentence is void if the court never had jurisdiction to sentence you in the first place. But no one is claiming here that Judge Mandel did not have jurisdiction to impose this sentence. And of course he did, because everybody went back to Judge Mandel to ask him to vacate and impose a new sentence. What the Commonwealth is saying is that under the petitioner's argument, it would be a totally unworkable system where how the line could be drawn if decades down the road someone could come back and say, I never should have been in, and all of the unforeseen consequences that could flow from a judgment that never should have happened, therefore it was unlawful all along, as though it never did happen. Yeah, and I cite in my brief a whole list of statutes that where crimes would be called into question, convictions, because they depend upon the person being a quote-unquote prisoner. And the defendant's argument here, boiled down to its essence, is that I was not a prisoner within the meaning of the SDP statute because my sentence was void.
If you posit that the hearing, I think you would agree with this is the Allen case, but let's say that the hearing that Judge Mandel had on whatever day did, in which he vacated the sentence, had happened February 28th rather than March 6th. I think those were the dates. So that when you went in to see Judge McCann in the Superior Court on March 1st, it was after. You would agree that you couldn't have done that, wouldn't you?
I would.
What if the prisoner has not been released? He's still being validly held because there's some...
That's Allen.
But he's not held under a sentence. Here he was held under a sentence under legal process.
So it's just who gets to the court, who gets to the Superior Court courthouse quicker.
And at times it does come down to that. In the SDP cases, the petition has to be filed while the person is still in custody. There were cases when the statute was first enacted where it was literally the day that the person was scheduled to be released or the day before, and the petitions were being filed, and there was still jurisdiction, and the court rejected challenges to those cases because that's the way that the statute is written, and lawful process was still in effect, as it was here.
Yeah. The existence of the prior judgment and even the questionable validity of the prior judgment may not result in a one-size-fits-all approach to all these different statutes that you're talking about. The escape is a crime. The commitment as an SDP person is not a crime. It's a remedial measure. And there may be different policy reasons for applying any questions about the validity of the underlying incarceration, depending on what's being affected.
There may be, Your Honor, but we all know that when an opinion is issued by this court using certain language, people take that language and they try to support an argument that where maybe the facts aren't exactly the same, but stretch it a little.
And then a judge takes a look, because you have to go to court, and a judge says, no, I don't think they meant to stretch it.
Or perhaps not. It's just the Commonwealth's argument is that as the law stands now, there is a very predictable, bright line rule. If you are held on valid legal process, that stands until a judge strikes that sentence. It upholds the important role of judges in determining sentences and in responding to challenges to custody. It does discourage any sort of self-help, and it is a workable rule, unlike the rule that the petitioner is advocating for, which I think would have many unforeseen consequences.
Can I ask you one further question? The remedy or the relief one gets if they are being held pursuant to a Pagan violation, so-called.
Yes.
Is it release or is it resentencing?
It's generally resentencing. As I've seen, it's always been a motion to strike or amend an illegal sentence.
So if it's resentencing, could the person essentially then be sentenced to a longer period of time?
That's what the Commonwealth actually asked for in this case. And initially, both parties agreed, and that's the sentence that the judge imposed in the morning with more committed time. But then the judge decided that if he did that, because the original plea had been an agreed plea, that he would then give the defendant the opportunity to withdraw the plea and have a new trial. So then a new agreement was made with no new committed time. But yes.
Ordinarily, it's a resentencing in which, because the judge at the time was imposing lifetime parole as a part of the sentence, could literally resentence him and increase the time period of incarceration.
Right, because all the parties believed that there would be this period of supervision, so perhaps less incarceration was imposed.
So automatic release is not necessarily the remedy.
No, and that's why I say that until Judge Mandel did what he did, it was not clear what would happen, regardless of the papers that had been filed by the parties. It was the judge who had to make that order to give it effect.
Was the defendant being held on any other commitment?
Not at that time. He had committed a new crime, but the sentence for that new crime had expired, and then he was serving his 4th lifetime parole violation.
Thank you, Ms. Lozano.
Thank you.